Hello, my name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about the Stored Communications Act. The Stored Communications Act is a law that went into effect in 1986. It has to do with what they call Internet Service Providers, or ISPs, and how they store information having to do with individuals in law enforcement type settings, meaning that certain communications can be gotten or requested if it is requested via subpoena or a warrant. The Fourth Amendment of the U.S. Constitution protects U.S. citizens against unreasonable search and seizure, and people interpret that to mean the protection of someone's sort of physical space or their property, like their home, that you would need a warrant for. But there are other occasions where the Stored Communication Act is being applied, where a company does not necessarily, or a government does not necessarily need a warrant. Perhaps it can be a subpoena, which is a lesser threshold. So for a warrant, you need probable cause and to get the warrant, where a subpoena, probable cause doesn't necessarily come into play. People are concerned, or have been concerned for many years, about the Stored Communications Act, not only because it has these separate and different levels of sort of privacy rights of the individual as it relates to either sort of their personal and physical being and their surroundings versus their data that is in the cloud or someplace else. 1986, things that we do today, like go on social media, or the way that we use the internet, or the way we use phones, a lot of the technologies that we use in our day-to-day lives didn't exist in 1986. So companies are really stretching to try to apply new issues or new cases in technology with the Stored Communications Act. Except recently in 2018, there was a case, a Supreme Court case called Carpenter. And the Carpenter case had to do with the constitutional rights of an individual to have their information given over to a court or to law enforcement that they deemed was a violation of their Fourth Amendment rights. So this particular data that they were talking about was literally their location data from cell towers. So under the Stored Communications Act, the way it's written or the way that people interpret it, these law enforcement people can ask for a subpoena, which has nothing to do with probable cause or a warrant, having to do with the calls that were made back and forth, which are more transactional records. But in order to get the cell phone data, the Supreme Court, in terms of the location data of the individual, the Supreme Court ruled that that was a violation of that person's Fourth Amendment rights, and that in that case, law enforcement agencies do need a warrant or probable cause in order to go after that type of data. So it remains to be seen how any laws, if any, will come about that will amend or supersede the Stored Communications Act, especially because, again, there are new technologies, new data types, new modes of transportation. After all, the Stored Communications Act is really about stored communications, so it doesn't really talk about data that's in transit, things like ephemeral messaging, text messaging, things that are being caught or things that are being transmitted. So there's a lot of open area in the Stored Communication Act and how that relates to individual persons' privacy in the U.S. Thank you.